So we welcome you back to the interview room. I'll ask you the first question. It is in two parts. The first part, what does the principle of inherent jurisdiction entail? Then the second part, give 3 instances where the inherent jurisdiction of the High Court is ousted.
Thank you very much, Chief Justice and the commissioners. So I would like to start by giving a definition of inherent jurisdiction. So inherent jurisdiction would be the power that a court has, and in this instance, we are talking about the High Court. The power that it has by virtue of its existence as a court, as opposed to a power that is conferred on it by a statutory provision or the Constitution. So maybe to further explain that explanation, I would want to give a counter-example of a court like the Magistrates' Court, which is said to be a creature of statute, and therefore it can only perform those functions, or it can only exercise those powers that are conferred on it by statute. The High Court, on the other hand, has got inherent jurisdiction in the sense that it can exercise all powers and functions except those that are specifically excluded from its jurisdiction by law. And then on the second question, whereby you have asked me to enumerate 3 instances in which the inherent jurisdiction of the High Court is ousted. The first is in relation to labor matters. And I would say that because labor issues are provided for and are dealt with in terms of the Labor Act, the inherent jurisdiction of the High Court is therefore ousted in relation to labor matters. And then the second instance would be in relation to some constitutional matters. So we know that there are some instances in which the High Court there are some constitutional matters over which the High Court does not have jurisdiction. And the example that I can give is where the constitutional matter relates to the validity of a law or the conduct of the President and Parliament. In those 2 instances, the inherent jurisdiction of the court would be ousted. And then there could also be matters, this would be the third instance, there would also be matters which a statute reserves specifically for adjudication by other authorities. And the High Court is only authorized to exercise appellant or review jurisdiction And so in those matters, the inherent jurisdiction of the court to act as a court of first instance would be ousted. That would be my answer, Chief Justice.
Yes, thank you. Then the second question is in two parts. The first part is name two situations provided for under the High Court Rules 2021 in which an order or a judgment of the court may be rescinded. And B, what two requirements in respect of each type of case must a judge address before rescinding the order or judgment?
Thank you, Chief Justice. So the first instance, or the first situation in which the High Court judge has got the power to rescind his or her own judgment would be in instance where there has been a mistake, in the sense that the judgment was handed down by a judicial officer laboring under a mistake. Secondly, a court may also rescind its own judgment that has been issued in default of one of the parties. So in the first instance, where the judgment, that is the rescission of which is being sought, was a judgment that was issued in error, it is then incumbent upon the judicial officer to explore and to scrutinize the matter that is before it to see whether there was a genuine error. And once the court has determined that the judgment was issued in error, then there may be no need to proceed into an inquiry regarding the prospects of success, should the matter then proceed. In the second instance, where the judgment, that is the rescission of which is being sought, was issued in default, then the court must inquire into the reasons for the default. In other words, what are the reasons why the defaulting party did not turn up? And there must be just and sufficient cause for the default. And then secondly, the court, and if the court is satisfied that there is just and sufficient cause for the default, then they move on to the second stage of the inquiry, which is to ask whether there are any prospects of success. If the judgment is rescinded and the matter is allowed to proceed as a defended matter. That is my response.
The third question is in three parts. The first part, what do you understand by the concept of presumptive penalty? The second part, what is the difference between a presumptive penalty and a minimum mandatory sentence? Lastly, state two effects the sentencing guidelines have had on the criminal justice system.
Again, thank you, Chief Justice. So a presumptive penalty would be the penalty that is provided for as being applicable to a particular offense in terms of the sentencing guidelines that were published, I think it was last year. And the presumptive penalty is supposed to guide the judicial officer in the sentencing of an offender. And the requirement is that where the judicial officer wants to, or perhaps considers that he or she should impose a penalty that is different from the presumptive penalty, then they must justify that departure from the presumptive penalty by way of an explanation. And that explanation has got to be part of the judgment. And then secondly, the second question is, what is the difference between a presumptive penalty and the minimum mandatory sentence? So I'll take it that I have already explained what my understanding is of a presumptive penalty. So to distinguish that from a minimum mandatory sentence on the other hand, so this is a sentence that is imposed by Parliament in a statute for a particular offense as a minimum penalty for that offense. If I can give an example of, say, the Trafficking in Persons Act provides for a minimum mandatory sentence for those found guilty of violations of that act. However, the judicial officer is not obliged to impose that minimum mandatory sentence irrespective of other considerations. He must take into account special circumstances. And those special circumstances are any circumstances related to the commission of the offense, which the judicial officer ought to take into account, that might induce him or her to impose a penalty lesser than the minimum mandatory. My apologies, Chief Justice. What was the third question? I tried to write it down.
It is state two effects.
Okay.
The sentencing guidelines have on the criminal justice system.
Thank you.
Yes, let me repeat it. I was off line.
Okay.
The question is, state two effects the sentencing guidelines have had on the criminal justice system.
So for me, the first effect of the sentencing guidelines on the criminal justice system is that for the first time, I think they recognize what one might call hate crimes, in the sense that they provide for a stiffer penalty for crimes that have been committed by accused person motivated by bias. Bias against a person on any of the grounds that are, on any of the grounds upon which discrimination is prohibited in terms of Section 56, subsection 3 of the Constitution. So that is one effect that although of course the sentencing crimes themselves, they don't make specific mention of the word hate crimes, but when one looks at that model of sentencing, the fact that they give greater recognition to the motivation for the commission of a crime when it comes to sentencing, I would say that is a welcome introduction to the criminal justice system in terms of protecting vulnerable groups from the criminal conduct of others. The second effect of the sentencing guidelines, to me, I feel like they narrow the scope of discretion on the part of judicial officers when it comes to imposing sentences. So it's very possible that when a judicial officer is imposing a sentence for a particular crime, their own personal values and idiosyncrasies can be brought to bear, and their own beliefs can be brought to bear on how they are going to sentence the offender. So what the sentencing guidelines do is that they narrow that scope and they mitigate the risk of arbitrary action being taken when it comes to sentencing.
All right. The last question, the fourth question, has two parts. The first part, state 3 principles that govern the conduct of virtual hearing proceedings in the High Court. And B, what is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
So, to answer the first question on the 3 principles governing the adoption of a virtual hearing, the first one would be the need to reduce and curtail time and costs in legal proceedings. And then the second principle would be the need to ensure the speedy resolution of disputes, and the third principle would be across the board training for all the players that are involved in the administration of the systems. This would be the legal practitioners, the court officials, and the judicial officers. So the role of the judge in the adoption, maybe if you can please refresh my memory, sir, with regard to the second question.
What is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
Okay. So the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court, in my view, one of the key roles of the judge would be to make sure that all the parties have been served, to make sure that all the parties are familiar with and have been served with all the information that would enable them to attend the virtual hearing. For instance, I have been party to virtual hearings that were not going on very well because of internet connectivity. And the judge managed in each of those instances. The judge played a facilitative role by inviting us to then attend to alternative proceedings in his chambers. So in that case, I got the impression that the judge played a facilitative role in making sure that all the parties were present, they were able to attend, and that also the parties had also been served to make sure that there had been adequate service of the proceedings to the parties, and also to make sure that all the pleadings had been properly uploaded into the system.
Yes, thank you. I will now hand you over to the other commissioners for further questioning. Yes, CJ.
Thank you, CJ. Good afternoon.
Good afternoon, Deputy CJ.
Yes, I might have more than one question, but we'll see. You have had, I see from the papers that you submitted that you have had a varied legal career. You have, for instance, been legal admin officer to the Ministry of Local Government. You have been counsel to Parliament. You have been a lecturer of law. You have been advocate of the superior courts, and so forth and so forth. So, do you think the transition from all that to the bench might present challenges for you?
No, Deputy Chief Justice, I don't think so. I don't think it's a transition. I don't see it as a transition as such. I actually see it as a natural progression of all the varied experience that I have had. As you have correctly put it, I have interacted with the law in virtually all the sectors of society and all the sectors of the economy. I've worked for the executive arm of the government. I've worked for the legislative arm of the government. I've been in the academia. I've been in the development sector. I've been in private practice. So I think rather than my quest for a judicial appointment being seen as a transition, perhaps it should be seen more as a natural progression, or maybe as a cap on all the work that I have done previously. I think it will make me a well-rounded judicial officer, the fact that I've got all that experience.
Yes, thank you. I have a second question for you. Judicial officers are expected to be impartial.
Correct.
What does the ethical requirement of impartiality, in your view, mean for judicial officers? You could also relate to the issue of recusal by a judicial officer to hear a case.
Yes, Deputy Chief Justice. So the value of impartiality of judicial officers is something that is inherent in the principle of the rule of law, and specifically it is provided for in section 164 of the Constitution, which articulates the value of independence, both institutional independence and also personal independence of judicial officers. And then also further articulated in the Judicial Code of Ethics, and expanded upon, I think, by the jurisprudence that has come out of the courts around what it means. So when you take all that into consideration, impartiality, in a nutshell, means that the judicial officer must treat all persons fairly and governed by the principle of equality without regard as to the status of that person, firstly. And then secondly, the judicial officer also has got an obligation to ensure that his or her conduct does not bring their impartiality or their independence as such that their independence and impartiality might be called into question, then they have got the obligation to recuse themselves, that is to say, to excuse themselves from adjudicating on a particular matter.
Yes, thank you.
Thank you.
Thank you, CJ, and good afternoon, Ms. Naison. Still on the question of impartiality, integrity, code of conduct, and so forth, is questioned by the last commissioner. Can you explain how you would handle a situation where, for instance, a legal practitioner appearing before you in a pending case has requested to see you privately? That's the first part. And in your view, to what extent can judicial officers interact with legal practitioners outside court work?
Okay.
And also outside proceedings? Thank you.
Thank you very much, AG. So on the question of private interviews between a judge and a legal practitioner, that would absolutely not take place unless maybe in very exceptional circumstances, of which I cannot think of what an exceptional circumstance might be. However, in all other circumstances, it would not be proper for a judicial officer to entertain a meeting with a legal practitioner in private. The proper thing, so if a legal practitioner were to request to meet me as a judicial officer in private, I would require them to bring the legal practitioner on the legal practitioner or the legal practitioners who would be representing the other litigants in that matter. And of course, I would also require an officer from the registrar's office to be present in that meeting. And I would also require that whatever we are going to discuss in that matter is a case that is material to a matter that could be before me. It could be for case management, it could be maybe they want to seek an excuse, or maybe they want to seek an explanation pertaining to an order that I would have made. I would absolutely not agree to see a legal practitioner in private. And then on the second question, on to what extent would it be appropriate for a judicial officer to interact with legal practitioners outside the circumstances of judicial proceedings? Is that the question? Yes. So in my experience, I have interacted with judges outside judicial proceedings, but in very controlled circumstances. And here I'm not talking of perhaps judicial officers that could be related to me, and we have to meet in the context of that personal relationship. I'm talking about maybe meeting judicial officers in my capacity as a legal practitioner. So there are symposiums that I held from time to time. I remember last year there was a symposium held in Kariba for judges to discuss the introduction of the integrated electronic case management systems. I was invited and I attended, and I got the opportunity, which I welcomed very much, to interact with the judicial officers. But the interaction was, it wasn't the same kind of interaction, say maybe that I would have with a friend. We would have dinner together, discuss a few cases on a very general basis. So that kind of interaction, in my view, would be appropriate. And also sometimes you have, judicial officers that teach at the University of Zimbabwe, where I also teach. So an interaction in that context, and as academics would not be out of order. Thank you, AG.
Thank you, Chief Justice, and good afternoon, Ms. Naison. Now, my question is this. You are a teacher of law, and I can see you have had an illustrious career. And the question that I want you to address is, if assuming there is a recommendation that is made and you are made a judge, what do you see your career going forward? And what is it that you think you want to bring to the bench? And what are your areas of passion? In other words, where do we see you in 10, 20 years from now? What are your aspirations? That's what I want to hear from you.
Okay. So, Commissioner, you might know that this is not the first time that I'm appearing before this commission. This is actually the third time, meaning that this is an appointment that I have sought and that I really want, because I see myself. That is where I see myself. And you are talking about in 10 years' time, 20 years' time. Within that time frame, I hope to have developed my acumen as a judicial officer, and I also hope to have contributed to the development of jurisprudence, particularly around the protection of vulnerable groups in Zimbabwe. And by vulnerable groups, I'm talking about children, women, detained persons, the elderly. I know that the Constitutional Court has does have some jurisprudence around, impressive jurisprudence around those groups. But I think that is the added value, perhaps, that I can bring because of the passion that I have, and also because of the experience that I've had working in that area.
Thank you, Chief Justice.
Yes.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
I wasn't sure what you were going to call me. Please describe a situation where you made a mistake in your legal career and how you dealt with it.
Okay. So when I first became an advocate, and I was still getting used to the process of getting instructions from attorneys and then representing them and taking instructions and then appearing in court. I made a mistake once. I think it must have been 2018 or 2019. I made a mistake in which I did not appear before a judge for a subsequent appearance after we had initially appeared, and then the judge says, you need to appear again. I think it was maybe a week. So I did not seek instructions. The mistake that I made was that of failure to get clear instructions from the instructing attorney as to whether or not my brief extended to that subsequent meeting with the judge. And so I did not attend. So the judge was not pleased. As I later discovered in a judgment with some scathing remarks about my conduct. So I sought to rectify that error by then going back to the judge and explaining my position and apologizing and making it clear that my failure to attend was not as a result of delinquency or a lack of respect for the court, but that there had been a miscommunication between myself and the instructing attorney.
How did that mistake affect the outcome of the case?
I'm not so sure about the final outcome of the case because the matter to which that mistake related was an interlocutory matter. So like I said, it was, I think in 2018 or 2019. So I'm not so sure about about the final outcome of the case. But I do recall that that was a painful mistake that I made that I had to then correct.
Thank you, Chief Justice.
Yes, thank you. Commissioner.
Just one question for you. What is your understanding of the independence of the judiciary in relation to the executive and parliament?
Thank you, Commissioner. So my understanding of your question, I think, is that it relates to the institutional independence of the judiciary. So the independence of the judiciary as articulated in section 164 of the Constitution relates to the freedom of the judiciary from interference in the exercise of its functions and in the exercise of its powers by the executive arm of the state. So there are various mechanisms that we have in our constitutional system which guarantee that independence of the judiciary. First of all, just the principle of separation of powers in itself is a mechanism that is in our constitution, which is meant to guarantee the independence of the judiciary. Then we have provisions within our constitution which protects the factors or which protect the determinants of the independence of the judiciary. And here we are talking about the security of tenure of judicial officers that is provided for in the Constitution. And then we have also got provisions relating to the financial independence of the Judicial Service Commission. And then we also have got provisions within our Constitution with very clear procedures about how to address a situation in which a judge might have conducted themselves in a manner that would require them being relieved of their duties. So all those procedures with inbuilt due process are designed to ensure that there is independence of the judiciary and that judicial officers are able to execute their functions without any fear or favor from the members of the executive.
Thank you. I'm answered.
Yes, thank you.
Good afternoon to you, Mrs. Darangwa.
Good
How are you
afternoon, Judge
feeling?
President. My name is Mrs. Damiso. Darangwa is the maiden name.
Darangwa is, I see. Thank you for the correction.
That's all right.
I do have one question for you.
Yes.
Where a court is dealing with a court application and it realizes, that is the court, that there are material disputes of fact arising on the papers before it, that it cannot resolve on the same papers, what are the options that are open to that court?
So when a court is dealing with an application, which ordinarily is a procedure that allows the court to dispose of the matter on the basis of the papers without hearing evidence, if that is the case before a judge, and then the judge realizes that there are material disputes of fact that are not capable of being resolved on the basis of the papers, and that that there is a need to hear evidence from the parties, oral evidence, then one option that would be available to a judge is to order that the proceedings be transformed into an action, so to speak. So how I've seen it done in the cases that I have been involved in is where the judge will direct that the evidence that is provided for in the affidavits be filed before be adopted for the purposes of an action procedure. And then the judge might also require that the parties, they call in witnesses to actually give oral evidence on the matters that are in dispute before the court. And so the proceedings then filed might actually then be transformed into the proceedings that one would ordinarily encounter in action proceedings, like the summons and the declaration. For example, the application might then serve as the application, and the founding affidavit might also then serve as the declaration for that purpose. So the judge would then also require the parties to narrow the issues before proceeding to trial, so that the court is clear about which are the material disputes of fact which must then proceed by way of action.
So how many options is that you've spoken about?
That would be one. The other option, in my view, would be maybe for the judge to dismiss the application and require the parties to proceed by way of action.
Two options.
Those are the options that I have, Judge President. I cannot think of a third one right now.
Very well. Thank you for your answer.
Good afternoon.
Good afternoon, Commissioner.
I see you've been involved in various work in terms of consultancy, and I think one of them is the Gender and Sexual Harassment in the Public Service Academy. What has been your contribution in that? Your direct contribution?
Okay. So my involvement in that consultancy was not about drafting the sexual harassment policy, but I was involved in the training of trainers. And those trainers were senior officers within the Public Service Commission, to train them on the provisions of the policy, and also to train them on how the policy dovetailed into the misconduct provisions governing the Public Service Commission, with a view that when those trainers had been trained, they would then roll out the training to the rest of the public service. But I think a more relevant assignment that I have undertaken in relation to that, perhaps it might not have appeared in my CV because it is that recent, is the development of the sexual harassment policy for the Law Society of Zimbabwe. So I was commissioned by the Law Society of Zimbabwe to develop their sexual harassment policy, which I did together with a colleague, and it was then commissioned, I think, on the 8th of March this year. And as we speak, it is extant.
Thank you for that.
Thank you.
Okay. Good afternoon, Ms. Darangwa, Mrs. Damiso.
Yes, Commissioner.
Thanks for clarifying, because I was thinking Darangwa was your middle name as it is shown on your nomination papers. And I was then wondering whether we were talking to the right person, because your certificates talk of a different person without that middle name. But thanks for clarifying. I've got a question. In the question asked earlier on by my colleague, Commissioner Masiemo, about where you would like to be in the next 20 years, you then pronounced a biased position with regards to the jurisprudence development. Now, my question to you would be, judicial officers are expected to be impartial. What does the ethical requirement of impartiality mean for judicial officers? And also, in your response to that, would you may want maybe to revisit your earlier response to Commissioner Masiemo's question. I don't know if I'm clear.
I think so.
Okay.
I will attempt. So, when I was responding to Commissioner Masiemo's question, and I appear to have maybe given a question that is biased towards vulnerable groups, it is all in recognition of the fact that these are the groups that normally are disadvantaged when it comes to access to justice. And I think our jurisprudence is resplendent with examples of how the rights of these groups are usually violated. For example, children, people with disabilities, and they tend to fall through the cracks unless someone pays a deliberate eye on them. So, so my answer, instead of it being seen as a biased answer, I think that perhaps it could be helpful. It could be seen as an answer that would promote the values that are of equality and non-discrimination, which are articulated in Section 56 of the Constitution, which in its letter recognizes that there are certain categories of people in society who are susceptible to discrimination and to being treated with lack of equality. And they are enumerated on the basis of sex, gender, disability, age, social status. And so my answer is to say that should I succeed in this appointment, then I foresee my role as playing a significant contribution towards the protection of the human rights of those groups, specifically because they tend to be forgotten and they tend to be marginalized.
I just want to make a follow-up, because as a High Court judge, you will have that side of things, those people that you have defined as vulnerable, and the other litigant. Now, what impression will it give to a litigant who knows that you are biased towards this particular vulnerable group?
Okay.
What impression will it give to you as a High Court judge?
Okay, Commissioner, if I can refer you to the code of ethics for judicial officers, there is a specific provision within that document, within that statutory instrument, which requires judicial officers to specifically cast an eye towards those kinds of people that we are talking about, the people that are marginalized, the people that are vulnerable, for as long as the casting of an eye is in relation to a material circumstance, to a circumstances that is not material to the dispute that is before that judicial officer. So the code of ethics of judicial conduct actually requires judicial officers to cast an eye to those types of people, specifically because they are vulnerable, because they are marginalized, and also because they tend to be forgotten if a deliberate effort is not made to protect their rights or to facilitate their access to justice.
Thank you, Chief Justice.
Yes, thank you. Yes.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
Yes, your CV doesn't tell us much in terms of your life outside professional work. So my question is, what activities or hobbies do you enjoy outside work, and how do they contribute towards your personal growth and development?
Okay, so outside work, so I have what you might call a large family, 5 children. So my activities outside work involve really interacting with my family. Particularly, I have 2 very small children, twins. So a lot of my time is spent trying to develop the sporting abilities of those children. For instance, I take very seriously their involvement in sport at school. So I already have got a very busy schedule teaching at the university, and also my private practice in the consultancy work that I do, and also the activities that I go, that I'm involved with in my church. But the little time that I have on my hands, the spare time that I have on my hands, I think I spend much of that time trying to develop my children's education in terms of their academics, but I think particularly in terms of their sport. So what was the second rank of that question, Commissioner?
The question really centers on your how the activities you do outside work are then related to your personal growth and well-being and development.
Okay, so those activities that I have just enumerated, where I try to develop my children, they bring me in contact with educators. These will be the teachers at the school where my children go to. They bring me in contact with the sporting coaches that coach my children in the various sporting activities, and also the parents of all the other children. So those interactions that I have with the parents and with the educators, I have found that they help with my personal development, in the sense that I get to learn a lot about parenting. I also get to learn a lot about child development, and I also get to learn a lot about the development in sport, internationally and also nationally.
Thank you, Chief Justice.
Just one question. Taking into account your professional status, what you have been doing as a legal practitioner, we look at your CV, is very rich in self-application. How will you fit into the judiciary setup? Are you aware that the judiciary now has performance management and monitoring systems for judges?
Yes, I am aware. Oh, sorry. Had you finished, sir?
You are aware?
Yes, I am aware that judicial officers are subjected to performance appraisal, and it's not something that I would be uncomfortable with or I would be unfamiliar with should I succeed in this appointment, because in all the roles that I have undertaken, I've been subjected to performance appraisal. At the University of Zimbabwe, I recently was appointed as a permanent member of the teaching staff, and that was done after a very rigorous and extensive performance appraisal system. And also in the Parliament of Zimbabwe where I've worked, in the government where I've worked, and also for the United agencies that I've worked, they value very much the administration of performance appraisal systems. Even in the various consultancies that I've undertaken, every time when one has conducted a consultancy, they are subjected to an assessment and an appraisal. And the outcome of that appraisal can very well have an impact on the ability to then attract further opportunities. So yes, I am aware that there's a performance appraisal system within the JSC, and I'm not afraid of it. I am quite hardworking. I am quite hardworking, and I don't think I would fall short of the standards of any performance appraisal system.
Yes, thank you very much. We have come to the end of your interview. You are excused.
Thank you, Chief Justice. Thank you, Commissioners.